Having examined the differences between judicial and non-judicial foreclosure, we now turn to a voluntary alternative available to borrowers facing financial hardship: the deed in lieu of foreclosure. This arrangement allows a borrower to avoid the formal foreclosure process by voluntarily transferring ownership of the property to the lender in exchange for the cancellation of the debt. While it does not erase the borrower's credit damage entirely, it can mitigate further financial and legal consequences associated with foreclosure proceedings. A deed in lieu of foreclosure, often called a friendly foreclosure, is governed by the principles of contract and property law and recognized under ARS paragraph 33705. It is a negotiated settlement in which the trustor, borrower, conveys title directly to the beneficiary, lender. Once the lender accepts and records the deed, the borrower's obligations under the loan are typically satisfied, and the lender assumes ownership of the property. Because it is voluntary and does not involve the courts, it is usually faster and less costly for both parties than a judicial or non-judicial foreclosure. For example, imagine a borrower in Gilbert who purchased a home during a market peak, but now owes more on the mortgage than the home is worth. After falling behind on payments, the borrower approaches the lender to negotiate a deed in lieu. The lender agrees, provided the borrower transfers the property free of additional liens. Once completed, the borrower's loan balance is canceled, and the lender takes title to the property. This arrangement allows the borrower to avoid the public sale process and the emotional toll of foreclosure. However, the transaction is not without important conditions and implications. Before accepting a deed in lieu, lenders typically require the borrower to submit financial documentation proving genuine hardship. They also conduct a title search to confirm that no junior liens, judgments, or encumbrances exist. If other liens are present, the lender is unlikely to proceed, since accepting the deed would make the lender responsible for those subordinate debts. In such cases, a foreclosure is often preferred because it clears subordinate liens from title after the trustee's sale. A valid deed in lieu must include a written agreement between the parties that clearly states the borrower's intent to surrender the property voluntarily. The document must be executed, acknowledged, and recorded in the county where the property is located, following the requirements of ARS. Paragraph 33-401. The lender then issues a release of lien or satisfaction letter confirming the debt has been settled. The transaction is final once recorded, and ownership fully transfers to the lender. The implications for borrowers vary depending on the agreement terms. In most cases, the borrower is released from further personal liability for the debt, similar to the protections offered under Arizona's Anti-Deficiency Statute, ARS. Paragraph 33-8 However, if the lender explicitly reserves the right to seek a deficiency, or if the property does not meet the statute's residential criteria, the borrower could remain liable for any remaining balance. Therefore, careful review of the written agreement is essential before signing. From a credit standpoint, a deed in lieu is generally less damaging than a full foreclosure, but more impactful than a short sale. It may remain on a borrower's credit report for up to 7 years, but is often viewed more favorably by future lenders because it reflects cooperation and resolution rather than legal enforcement. In some cases, lenders may offer relocation assistance or cash for keys programs to encourage borrowers to vacate the property in good condition. For real estate licensees, it is crucial to recognize the ethical and legal limits of their role when assisting clients considering a deed in lieu. Under Commissioner's Rule R428-01B, a licensee must not provide legal advice or interpret the terms of such agreements. Instead, they should explain the general process, encourage communication with the lender, and refer the borrower to qualified legal counsel or a HUD-approved housing counselor. A practical example can illustrate this distinction. Suppose an agent is working with a couple in Queen Creek who have fallen behind on their mortgage. The couple asks if they should sign a deed in lieu offered by their bank. The agent can explain that the agreement would transfer ownership and possibly cancel the remaining debt, but must not advise whether they should sign it. Instead, the agent should recommend consultation with a real estate attorney to review the implications and ensure no deficiency liability remains. In summary, a deed in lieu of foreclosure represents a cooperative alternative to foreclosure, allowing both borrower and lender to avoid the costs, time, and stigma associated with the formal process. When executed properly, it provides closure and helps preserve the borrower's dignity and creditworthiness. Discussion. Why might a lender prefer a deed in lieu of foreclosure over a trustee's sale? Answer. It avoids the time, expense, and public nature of the foreclosure process and allows faster recovery of the property. What is one major condition that must be met before a lender will accept a deed in lieu? Answer. The property must have a clear title, free of subordinate liens or judgments that could transfer to the lender. How does a deed in lieu affect a borrower's liability for the remaining loan balance? Answer. In most cases, it satisfies the debt, but the borrower could still be liable if the lender reserves the right to pursue a deficiency. Review summary. A deed in lieu of foreclosure allows a borrower to voluntarily convey property to a lender as full or partial satisfaction of a mortgage debt, thereby avoiding the formal foreclosure process. It requires mutual consent, a clear title, and a written, recorded agreement. This approach benefits both parties by saving time, reducing costs, and limiting public exposure. However, borrowers must understand potential deficiency implications and credit effects. Real estate professionals should educate clients about the general process. Remain neutral and refer them to legal or financial experts for advice.